Your raise got lost in legal, HR told me. I nodded, thanked them, and went back to work. 3 days later, our biggest client's attorney walked into headquarters and served the CEO with a subpoena. The room went silent. Why is our $80 million partner suing us over an employee raise? The CEO demanded. Nobody had an answer. Then our company lawyer opened my contract, read one paragraph, and slowly looked up. His hand started to shake. I want to be precise about what I do, because precision is the entire point of this story. My title is Senior Contracts and IP Analyst. That description sits on my badge, my email signature, and the small placard outside my office door, which is not a corner office or a windowed office. It is a 9x11 room wedged between the server closet and the copy station, which smells faintly of toner and the specific kind of silence that accumulates in places where people don't like to linger. Nobody lingers outside my door. That is fine. That is, in many ways, the entire foundation of this story. Here is what Senior Contracts and IP Analyst actually means in practice. It means that before anyone in this company signs anything, the document crosses my desk. Every vendor agreement, every software licensing deal, every NDA, partnership memorandum, letter of intent, master service agreement, amendment, addendum, rider, and exhibit attached thereto. Every piece of paper that could, at some future date, become the thing that saves or destroys us. It all comes to me first. I read every word. I read the recitals. I read the definitions section, which most lawyers treat as boilerplate, and which is, in fact, the most dangerous section of any legal document, because definitions are the architecture that governs everything built on top of them. I read the footnotes. I have been doing this for 11 years. Before that, 3 years as a paralegal at a litigation firm, where a partner once slid a contract across his desk, pointed to a single clause and said, "That clause is going to cost a Fortune 500 company $60 million because somebody signed it without reading it." I want you to understand something. The most powerful thing you will ever hold in your hands is not a weapon. It is a contract. I thought about that for 11 years. The company grew. Funding rounds brought new people, new titles, new offices. The original general counsel left. His replacement arrived with an impressive resume and a set of golf clubs he kept in his office, and who, over time, I came to understand, had been hired primarily because he made the CEO comfortable at board dinners. His relationship with actual legal documents was, to be charitable, aspirational. He knew the vocabulary. He could speak fluently about indemnification and force majeure in the abstract, the way someone speaks fluently about surgery without knowing how to hold a scalpel. When documents needed to be reviewed, they came to me. When documents needed to be signed, he signed them. When credit needed to be taken, he was available. I did not resent this exactly. What I did instead was something quieter. I kept records. I documented my contributions. I preserved my drafts with timestamps. It would turn out that this habit was the most valuable thing about me. 3 years ago, we were trying to close the biggest deal in company history. The client was a defense logistics firm. They moved supply chains for government contractors, which meant their data infrastructure requirements were enormous, and their tolerance for error was precisely zero. They had evaluated 6 vendors over 18 months. We were the last one standing, not because we were the best option, but because we had not yet done anything disqualifying. The CEO wanted the deal badly. He talked about it the way people talk about things that have become untethered from rational evaluation. It was not just a contract. It was the thing that would make investors stop treating us like a promising startup and start treating us like a real company. The sticking point was intellectual property. The client had been through a vendor dispute that produced a licensing injunction and 6 weeks of operational disruption. They were not going to let that happen again. They wanted indemnification, representations, warranties, and audit rights. The CEO came to me directly, not through the general counsel. He stood in my office doorway at 7 in the evening and said words I had not heard from him before or since. "I need you to make this work, whatever it takes. Build it in a way that protects us and satisfies them and closes this deal." I spent 11 days on that contract. I worked through 2 weekends. I mapped the IP ownership chain from first principles, documented the authorship trail for every component of our core architecture, and drafted provisions that would satisfy a general counsel who trusted nothing without verification behind it. And then, in the royalty addendum, I wrote Clause 14C. The language established that if the company hit specific uptime and data volume milestones for 3 consecutive quarters, the individual identified on the signature page as IP architect would be entitled to a retroactive commission of 0.5% of gross contract value, payable within 90 days of milestone confirmation. Failure to notify and compensate within this period would constitute a material breach of the licensing agreement, rendering the license voidable at the client's election. I wrote that language for 2 reasons. The first was legitimate contract architecture. The clause created a paper trail establishing human authorship of the IP, which mattered for patent purposes and acquisition due diligence. The second reason was simpler. I had been at the company for 8 years. I had caught mistakes that would have cost 6 figures to unwind. I had watched people who contributed less than I did leave for roles that paid 40% more. I had watched people who contributed dramatically less get promoted into positions with equity and visibility that compounds over time. I signed the signature line, IP architect. I walked the document to the general counsel's office and placed it on his desk with a cover note. He glanced at the first page, initialed it without reading further, and told me good work. Let's get this closed. He did not read Clause 14C. Neither did the CEO when he signed the execution copy. The deal closed. The CEO announced it with a slide deck and champagne toast. I received a $50 gift card to a coffee chain and a handshake. I put the gift card in my desk drawer. I never used it. I went back to work. The milestones hit quietly, the way most important things do. There was no ceremony, no moment where someone walked into my office and said the numbers are in, the clause is active. There was just the data, accumulating in the system the way data does, patient and indifferent, waiting for someone to look at it. I looked at it. It was a Tuesday in the fall when I first ran the calculation. I was pulling quarterly performance reports for an unrelated audit, and I had the uptime logs open on one monitor and the agreement open on the other, and I understood what I was seeing before I had consciously decided to calculate anything. Quarter 1, 99.94% uptime. 8, 2 terabytes processed. Quarter 2, 99.97% uptime. 11.7 terabytes processed. Quarter 3, 99.98% uptime. 14.3 terabytes processed. 3 consecutive quarters. Every threshold cleared by a margin that was not close. The engineering team had been extraordinary. They had rebuilt the monitoring infrastructure twice. The CTO had given a board presentation about reliability as a competitive differentiator. The CEO had used these exact numbers in pitch decks to prospective investors. The numbers were celebrated. The numbers were broadcast. The numbers were, in Clause 14C, a contractual trigger. I calculated 0.5% of the gross contract value of $80 million was $400,000. With accrued interest and the penalty multiplier for delayed notification, the number grew from there. I saved the calculation to my encrypted drive. I closed the performance reports. I went back to what I had been doing. I did not immediately act. I wanted to see whether the company, through its own normal processes, would identify the trigger and come to me. This was a reasonable thing to expect. The clause was in a signed contract. The performance data was in the company's own systems. Any competent legal or finance function doing routine contract maintenance would have flagged it. I waited 6 months. In those 6 months, I received my annual performance review. Rating exceeds expectations. The review noted my exceptional attention to detail, my reliability, my institutional knowledge, and my contributions to several significant deals, including the Vanguard agreement, cited as a highlight of the company's year. The raise attached to an exceeds expectations review was supposed to be between 8 and 12%. I received 3%. The explanation cited market conditions and budget constraints. I thanked my manager. I went back to my desk. I waited another 6 months. Nothing happened. No one came to me about Clause 14C. No one in finance flagged the liability. The contract that sat in the fireproof cabinet in the secure document room was as untouched as it had been on the day everyone signed it. I understood by then what kind of company this had become. The email arrived on a Friday at 4:17 in the afternoon. I know the time because Friday afternoons in that office had a particular quality I had learned to track. There was a window, roughly between 4 and 5, when the people who made decisions felt the week releasing its grip and began to behave accordingly. Things that should have waited until Monday were said out loud in corridors or fired off in emails that the sender would have phrased differently on a Tuesday morning. The HR business partner sent this email at 4:17, which told me everything I needed to know about how much thought had gone into it. Subject: compensation review, Q3 adjustment, 3 short paragraphs. The first thanked me for my patience. The second acknowledged that my performance metrics remained strong. The third explained that due to current reallocation of Q3 liquidity into strategic acquisition channels, my raise request had encountered delays and had, at this stage, gotten lost in legal. Lost in legal. I read the phrase twice. Then a third time, not because I didn't understand it, but because I was making sure I had correctly understood what they believed about me. They believed I would read that phrase and accept it, that I would not notice the irony of telling the person who runs the legal function that something had gotten lost inside the legal function, that I would nod, close the email, come back on Monday, and continue doing the work they relied on and did not particularly want to think about. I sat with the email open for approximately 4 minutes. To my left, the sales team was celebrating a renewal deal on a contract I had restructured 3 months earlier. The person who closed it would receive a commission. I had received nothing for the restructuring. The celebration involved a cowbell mounted on the wall. To my right, the CFO was walking toward the elevator wearing a watch that cost more than I made in 3 months. I looked at the email again, lost in legal. I thought about Clause 14C. I thought about the performance milestones. I thought about the calculation sitting on my encrypted drive, $482,000, growing with interest every quarter while my raise got lost and the CFO bought watches. I closed the email without responding. I packed my bag. I walked past the sales floor. I pushed through the front door into the evening air. Some part of me had already moved past weighing options and into the quieter, more purposeful state that follows a decision. The state where you stop asking yourself whether and start asking yourself how. I drove home. I made dinner. I sat at my kitchen table and opened my laptop and looked at the contract language and the performance data and the calculation for a long time. Then I picked up my phone and called the client's general counsel. I need to explain what it feels feels like to make a decision like this, because people assume it is dramatic. They imagine a moment of righteous fury, a line crossed. They imagine the person who has been wronged finally snapping. That was not what happened. What happened was quieter. I sat at my kitchen table on a Friday evening with a cup of tea that had gone cold, and I felt something shift, not snap, shift, the way a tectonic plate shifts. I thought about the phrase lost in legal. I thought about the specific bureaucratic laziness of that construction, the way it used the vocabulary of process to replace the substance of accountability. Nothing gets lost in legal. Legal is a department staffed by human beings who make decisions. What the email meant, translated out of its comfortable passive construction, was, we have decided not to pay you, and we have decided that explaining that decision to you is not worth our time, and we are confident that you will accept this because you always have before. They were not entirely wrong about my history. They were entirely wrong about this particular moment. What I wanted was not revenge. Revenge is a retrospective project. It is about making the past cost something, which does not change the past. What I wanted was something more structural. I wanted the people who ran this company to understand that the world they inhabited, where contracts were things other people worried about and the person who worried about them was furniture, was not actually the world they inhabited. I wanted them to understand this the way you only truly understand important things, through direct and unavoidable experience. I wanted them to read Clause 14C. Beyond that, I wanted what the contract said was mine, $482,000, not as punishment, not as satisfaction, as payment, for work done, for milestones hit, for a signature on a document that every executive in that company had also signed and then forgotten. I opened a new document and wrote a clean summary of everything: the clause, the milestones, the timeline, the amounts, the breach, factual, sequential, sourced. Then I wrote one question at the bottom: what do you want to happen next? I sat with that question for a long time. Then I picked up my phone in the morning and scrolled to the contact I had been thinking about since I left the office: the client's general counsel. The client's general counsel answered on the second ring. He answered with his last name and nothing else, which was how he always answered, and which I had always appreciated for its efficiency. I said my name. He asked what he could do for me, moving past pleasantries at a speed that felt like respect rather than curtness. I told him I had been reviewing the master service agreement we executed 3 years ago. There was a pause. He asked which section. I said the royalty addendum, Clause 14C specifically. There was a longer pause, the kind lawyers produce when they recognize something they have been expecting to hear for longer than they would like to admit. He said, the IP architect provision. I said yes. He asked whether the milestones had been met. I said they had been met for 18 months. I said the 90-day notification and payment window had expired 18 months ago. I said I had not been notified. I said I had not been compensated. I said the company was operating their data infrastructure on licensed software for which the underlying IP architect had not received the commission the contract required. There was a third pause. The pause of a person doing several things simultaneously, processing what he had heard, evaluating its implications, and deciding how to respond without committing to a position before thinking it through completely. Then he said something I had not fully anticipated. He said, I flagged that clause before we signed. I told our executive team it was an unusual provision. They asked if it created risk for us. I said it did not, that if anything, it created additional protection for us in the event of a licensing dispute. They said fine, and we moved on. I have wondered, in the time since, whether anyone at your company read that clause after signing it. I said I did not believe they had. He asked what I was looking to accomplish. I told him I was not looking to disrupt the business relationship. I said I had spent 3 years building the foundation of the product they relied on. I was not interested in burning that down. I was interested in the company understanding the significance of what they had failed to do, and in receiving what the contract said I was owed. He was quiet for a moment. Then he said, I can send a formal notice of audit addressed to your CEO, CFO, and general counsel. It would cite the clause, list the milestone dates, and demand proof of compliance within 48 hours. That is a standard mechanism under the agreement. It is not a lawsuit. It is a compliance inquiry. I said that seemed like a reasonable first step. He said he would send it Monday morning. Then he said, I want to ask you something. Did you write that clause with this in mind? I thought about the honest answer. I said, I wrote it because good contracts account for things that have not happened yet. I wrote it because intellectual property has value, and the people who create it should be protected. I wrote it because 11 years of reading contracts has taught me that the provisions that matter most are the ones that everyone is too comfortable to worry about. He was quiet for a moment. Then he said, I will send the letter Monday. I said, thank you. We said goodbye. I put the phone down and sat in the quiet of a Saturday morning with the particular stillness that comes after a very important conversation has ended and before its consequences have begun. Monday morning arrived the way consequential Mondays always do, indistinguishable from any other. The coffee was the same. The commute was the same. The receptionist said good morning with practiced warmth. I sat at my desk. I opened my email. I answered 3 routine questions from a junior associate, reviewed a vendor NDA that needed 2 small amendments, and did my job. At 9:14, I saw the letter arrive. I did not receive it directly. It went to the CEO, CFO, and general counsel, which was correct, but I had been granted red access to the executive legal inbox years earlier during a due diligence process, and no one had ever revoked it. People forget to revoke things. This is one of the quieter organizational failures that accumulates in companies over time, and it is usually harmless, and occasionally it is the precise opposite of harmless. I opened the email from the client's general counsel in the executive inbox and read it, though I already knew what it said. 5 pages. The first cited the master service agreement by date and reference number. The second listed the performance milestone provisions of Clause 14C with specific quarterly dates and figures. The third documented the 90-day notification and payment window that had expired 18 months ago without action. The fourth stated that this failure constituted a material breach of the licensing agreement. The fifth made the demand: provide written confirmation within 48 hours that the IP architect compensation had been addressed, or the client would proceed to exercise its contractual remedies, including voiding the license. It was precise and complete, and left no interpretive gaps. At 9:22, the CEO forwarded it to the general counsel. Greg, handle this. Probably just standard compliance spam. Don't let them slow down the Q4 pipeline. At 9:38, the general counsel forwarded it to the CFO. Chad, they're asking about royalty structures. Do we have any of those? Just send them some generic financials. At 10:04, it landed in my inbox. The general counsel had forwarded it to me with a note that was, given the circumstances, so precisely wrong as to constitute a kind of accidental poetry. He wrote, Mara, Vanguard sent some formal nonsense about an IP audit and Clause 14C. Sounds like legacy contract gibberish. Can you draft a standard "we are in full compliance" response? Don't spend too much time on it. Focus on the merger due diligence. I read this message 3 times. Then I opened our internal compliance tracking system and created a new ticket. Status: pending executive review, awaiting sign-off. I wrote a note explaining that the clause referenced specific contractual provisions requiring cross-referencing with original performance logs, and that I needed a few days to complete a thorough review before we put anything in writing to the client. I sent a reply to the general counsel confirming I had received the request and would update him when I had something ready. He replied in 4 minutes. Sure thing. Take your time. Take your time. He had 44 hours remaining before the compliance window expired. I returned to the merger due diligence on my other monitor. I worked methodically through the afternoon, reviewing acquisition documents, flagging 3 provisions that needed attention before the letter of intent could be signed. I was thorough. I was careful. I produced the kind of work that everyone in that building relied on and almost no one thought much about. At 5:15, I packed my bag and left. Tuesday passed in the particular silence of a building that does not yet know something important is happening inside it. The general counsel sent me 2 other requests during the day, both unrelated to Vanguard. I handled them. I filed a compliance ticket update at the end of the afternoon. Status unchanged, review ongoing, no response issued to client. The 48-hour clock was running. Wednesday arrived. There was a finance team meeting in the afternoon. The accounts receivable manager flagged the pending Vanguard wire as likely a processing delay, a reasonable assumption based on historical patterns, and the team agreed to monitor it and follow up by Friday if it hadn't cleared. Nobody connected the pending payment to the compliance inquiry sitting in the legal inbox. It was in my domain and the general counsel had told me to handle it, which meant, from the finance team's perspective, it was handled. Wednesday evening, I updated the compliance ticket one final time before leaving. Status: pending executive review, awaiting confirmation of authorized response. No response issued to client. The 48-hour window expired at 9:14 on Thursday morning. I know the exact time because I had written it in my calendar. I sat at my desk and watched the clock reach 9:14 and thought about the fact that our biggest client had just been given legal standing to void an $80 million licensing agreement. At 9:21, my phone buzzed. A message from the client's general counsel. 2 words. Clock ran. I typed back, noted. He responded, your move or ours. I considered this for exactly 1 minute. Then I wrote, yours. Let me know when it goes out. He responded, tomorrow morning, 9 a.m. I put my phone face down and returned to work. That evening, the CFO sent an email to the finance team noting that the Vanguard wire still hadn't cleared and asking for an update by end of day Friday. Nobody contacted the legal team. Nobody looked at the compliance inquiry. Nobody opened the master service agreement. Thursday afternoon, the general counsel stopped by my office to ask whether I had made progress on the Vanguard response. I told him I was still reviewing the relevant contract language and wanted to ensure any response we provided was fully accurate. He said that was thorough of me and that the Vanguard thing was probably nothing. He left at 3:45. I stayed until 6. At 6:03, I closed my computer and left. Friday morning, I arrived at 8:30. I made coffee. I sat down. I opened my email. At 9:02, a new message appeared in the executive legal inbox. The sender was the client's general counsel. The subject line was, Notice of Immediate Compliance Action, Master Service Agreement. I did not open it. I already knew what it said. I leaned back in my chair and waited for the building to find out. It took 47 minutes for the building to find out. The first domino was the CFO. He arrived at 9:05, opened his email, saw the notice from the client's legal team marked urgent, and forwarded it to the CEO with a single word, explain. The CEO opened it at 9:22. I could observe from the angle of my desk through 2 sets of glass walls the precise moment he began reading, because his posture changed. He had been leaning back with the easy confidence of a man who runs a company having a good quarter. He came forward. He picked up his phone. He put it down. At 9:26, he called the general counsel directly. I watched the general counsel answer and immediately close his office door, which he rarely did. He was on the phone for 11 minutes. When he came out, he walked toward the CEO's office with a legal pad and his reading glasses on, which he only wore when he was actually trying to read something carefully, which in 11 years I had observed him do perhaps a dozen times. I watched through the glass walls as the two of them stood over a printout that neither had, until that morning, known they needed to read. The CFO arrived 30 seconds later. At 10:08, the general counsel came directly to my desk. He said, "Mara, that Vanguard compliance thing, what's our position?" I said, "The clause is a performance-triggered royalty provision. The milestones were hit 18 months ago. The 90-day notification and payment window has expired." He stared at me. He said, "What payment?" I said, "The IP Architect Commission, 0.5% of gross contract value, due within 90 days of milestone confirmation." He said, "Who is the IP Architect?" I looked at him for a moment. Not a long moment, just long enough. Then I said, "The signature page of the royalty addendum is on page 42 of the executed agreement. The copy is in the fireproof cabinet in the secure document room. I can pull it if that would be helpful." He was dialing before he finished walking back toward the CEO's office. He returned 8 minutes later with the expression of a man who had recently understood something he wished he had understood considerably earlier. He said, "The IP Architect on the signature page, that's you." I said, "Yes." He said, "You drafted clause 14C. I said, "Yes." He said, "And you've known about the milestone trigger for how long?" I said, "Approximately 18 months. He said, voice dropping. "And you didn't say anything?" I said, "I flagged it internally through the compliance system. The ticket is in the system with timestamps. I can send it to you if that would be helpful." He went back to the CEO's office. I watched through the glass as he showed them something on his phone. I watched the CFO's posture change the same way the CEO's had. I watched the CEO gesture with both hands, the specific gesture of a person who wants someone to fix something. I watched the general counsel shake his head. I looked back at my screen and answered an email from a vendor requesting a contract amendment timeline. The compliance notice had been in the building for an hour and 20 minutes. It was not a lawsuit, not yet, but the remedies it invoked included voiding the license, which meant our software could not legally be used by our largest client, whose entire data infrastructure ran on it. The $80 million contract was not the ceiling. The disruption in the event of a licensing void was a number that made $80 million look modest. The CEO understood this. I could see it in the way he sat down, heavily, and put both hands flat on his desk. The general counsel said something that appeared to be, "We missed it." That was accurate enough. I spent Saturday morning at my kitchen table with 3 documents open. The master service agreement, the updated calculation, $482,340, a blank page. On the blank page, I wrote what I actually wanted. The money was on the list, obviously. But money without acknowledgement is a quieter version of the same erasure. I could take a check and sign a release and go back to my desk, and everyone in that building would understand that the situation had been managed, not corrected. Nothing would change. What I wanted to change was the assumption at the center of everything, that the person who does the work that holds a building together can be treated like infrastructure. That quiet, reliable people can be underpaid indefinitely because they will absorb the loss and keep working. That a contract is something you sign and forget. I wrote 5 things. Full payment of all back compensation owed under clause 14C with accrued interest and penalties as specified. $482,340. A formal written acknowledgement from the company that the payment obligation had been missed and that the failure was organizational, not clerical. Signed by the CEO, the CFO, and the general counsel. A restructuring of my role to include direct reporting to the board's audit committee, bypassing the general counsel's chain of command, with autonomy to conduct contract compliance reviews without requiring executive sign-off at each stage. A revised compensation review process requiring audit committee oversight, closing the loop that had produced the lost in legal email. My legal fees paid in full. I looked at the list for a while. I decided it was fair, not retaliatory. Fair. I was asking for what the contract said was mine, plus the structural conditions under which it could not happen again through the same mechanism. I closed the document. I made another cup of coffee. I spent the rest of the weekend doing things that had nothing to do with contracts or leverage. I read a book. I took a long walk. I called my sister, who asked how work was going, and I said it was interesting. She asked what I meant by interesting, and I said things were in motion. I went to bed on Sunday night with the quiet certainty of someone who has already made the decision and is simply waiting for the world to catch up. Monday morning was the all-hands meeting. The company held it in the large break room on the 2nd floor, which doubled as a town hall space with a small elevated platform that the CEO used as a stage. Attendance was technically voluntary and practically mandatory in the way that many things at growing companies are technically voluntary and practically mandatory. I arrived early. I took a position near the exit at the back of the room. I like to be near doors when I am uncertain about what is going to happen in a room. I was not uncertain this morning, but the habit held. The CEO took the stage at 9:03. Dark jeans, blazer over a company-branded t-shirt, the studied casual of someone who has thought carefully about appearing not to have thought carefully. He talked about growth, about enterprise momentum, about the engineering team's reliability, reliability metrics. The slide behind him showed the uptime percentage for the previous quarter, the same percentage that had crossed the threshold in Clause 14C, as a large, clean number in the center of the screen. I watched from the back. I drank my coffee. I was patient. He was 3 minutes in when the double doors opened. 3 people walked in. The first 2 wore actual suits, not tech company casual, but structured, conservative, formal. The third I recognized immediately, the client's general counsel. He looked exactly as he always did in negotiations, unhurried, precise, wearing the expression of a man who has reviewed the relevant documents and found them satisfactory. The CEO stopped mid-sentence. 220 people went quiet. The client's general counsel walked to the edge of the platform. He said the CEO's name in the tone of a person conducting a formal proceeding. The CEO said yes in the slightly constricted voice of a person who already understands that something significant is about to happen. One of the suited men stepped forward and extended a thick document bound with a heavy black clip. He said, "You are being served. Civil lawsuit for breach of contract, intellectual property licensing violation, and willful non-compliance. Plaintiff, the client company. Defendant, this company." The room went so quiet I could hear the espresso machine through the wall. The CEO said, "Is this a joke?" The client's general counsel said, "Our office does not serve jokes. That is a lawsuit for $120 million, incorporating treble damages for willful non-compliance with a material licensing obligation." The CEO turned to the general counsel. Someone finally pulled the original contract. Our company lawyer opened it to page 42. He read Clause 14C once, then he read it again. He looked up at the CEO, then he turned and looked at me. I was standing at the back of the room with my coffee. I had not moved. Every head in the room followed his gaze. 220 people turned and looked at me. I did not look down. I held his gaze across the room and let the silence run for exactly as long as it needed to. Then I set my coffee down and walked forward. The crowd parted. I walked to the edge of the platform, reached into my jacket, and took out an envelope. I handed it to the general counsel. I said, "That is a letter of representation from my attorney. It establishes me as a party of interest in the complaint and activates whistleblower protection under applicable employment law, which means any adverse employment action taken against me in connection with this matter will be treated as retaliatory." I looked at the CEO. I said, "I believe we should move this conversation to the boardroom." The client's general counsel was already walking toward the door. The boardroom was on the top floor. Long, dark table, leather chairs, one full wall of glass looking out over the city. In the right light, the view was genuinely beautiful. It was not the right light this morning. We filed in. The client's general counsel took a seat on one side of the table. I sat beside him. Across from us, the CEO, the CFO, and the general counsel. The company's outside litigation counsel had arrived and opened a legal pad, which was the first indication I had seen all morning that anyone on that side of the table had engaged a professional who actually knew what they were doing. The CEO spoke first. He wanted to understand what was happening before anyone said anything they could not take back. The client's general counsel summarized. The complaint alleged breach of a material licensing obligation, failure to compensate the IP architect as required by Clause 14C following the confirmed achievement of the contractual performance milestones. Total claimed damages, $120 million, incorporating the base contractual obligation, treble damages for willful non-compliance, and litigation costs. Additionally, the license under which the client had been operating for 18 months was technically voidable pursuant to the breach. The CEO said, "What does technically voidable mean in practice?" The client's general counsel said, "It means we have the contractual right to treat our use of the software as unlicensed. We would not actually terminate our operations. That would not serve our interests. But it is a legally valid position that strengthens our standing significantly." The CEO looked at me. He said, "Mara, help me understand your role in this." I said, "I drafted the clause. I signed the agreement as IP architect. The milestones were met. The payment obligation was not honored. I notified the appropriate internal channels through the compliance system and was told to handle the inquiry myself, placing me in the position of being asked to draft a compliance response regarding my own unpaid compensation. I did not do that. I allowed the notification window to expire without a response." The CEO said, "You allowed it to expire." I said, "I flagged it internally." The response to my flag was to tell me to handle it and not spend too much time on it. The general counsel did not attempt to contradict this. He looked at the table. The CEO said, "What do you want, Mara?" I reached into my portfolio and placed the term sheet on the table. 1 page, 5 points. Full payment of all compensation owed under Clause 14C with accrued interest, $482,340. A formal written acknowledgement that the payment obligation was missed and that the failure was organizational, not clerical. A restructuring of my role to include direct reporting to the board's audit committee with autonomy to conduct contract compliance reviews without requiring executive sign-off at each stage. A revised compensation review process requiring audit committee oversight and payment of my legal fees. The CFO looked at the number. He said, "That is a lot of money." I said, "It is the number the contract specifies. I did not set the rate. The company signed it." The outside litigation counsel asked, "If you satisfy the IP architect's claim, does that resolve the complaint?" The client's general counsel said, "If the IP architect executes executes a release confirming the obligation has been satisfied, the foundation of the breach claim is cured, and our basis to proceed diminishes substantially. The CEO looked at the term sheet. He looked at the CFO. He looked at the general counsel. He said, "Greg, is the clause valid?" The general counsel said quietly, "Yes. It is clearly drafted and properly executed. It is valid." The CEO said, "And we signed it." The general counsel said, "We signed it." The CEO was quiet for a long moment. He picked up the term sheet and read it all the way through. He set it down. He said, "The board reporting provision. What does that mean in practice?" I said, "It means when I flag something, there is a mechanism to ensure it is reviewed by people with fiduciary responsibility, not forwarded back to me with a request to handle it." The outside litigation counsel reviewed the sheet and said the terms were reasonable, and the alternative substantially worse. He recommended accepting. The CEO picked up a pen. He signed. The CFO signed. The general counsel signed. The client's general counsel signed as a witness. I signed last. Then I capped the pen and looked at the CEO. He said, "Why didn't you come to me directly when you realized the milestone had been triggered?" I said, "Because I had been coming to you directly in various forms for 11 years, through performance reviews, through compensation conversations, through the quality of the work I produced." The answer I kept receiving was that my raise was pending, or delayed, or caught in a process. I wanted to know whether the company would identify and honor its own obligations without being prompted by the person those obligations were owed to. The answer turned out to be no. That answer was useful to have in writing. The CEO had nothing to say to that. I stood up. I said, "I'll have the release drafted by end of day. Your team can review it tomorrow." I walked out of the boardroom, down to my floor, past the sales team, who were unusually quiet, past the espresso machine, back to my small office by the copy machine. I sat down. I opened my computer. I went back to work. The wire transfer arrived on Wednesday, $482,340. I looked at the number in my banking application for a long time, not because I needed to keep looking at it, but because I had earned it over a long period of time, and I felt entitled to look at it without apologizing for that. Then I closed the application and made coffee and thought about what came next. What came next was the work, which had not stopped and would not stop. Contracts continued to arrive at my desk. Vendors continued to submit agreements that required review. The machine kept running. The difference was that I was running a different part of it now. The first audit committee meeting at which I reported directly took place 3 weeks after the settlement. I sat with 4 board members and presented a compliance review covering all active material contracts, flagging 7 provisions across 4 agreements that required attention before their respective option windows closed. None of the 7 had been flagged by the general counsel's office. 3 had risk implications that, unaddressed, could have produced situations similar to Clause 14C. The audit committee chair, a woman who had built 2 companies and sold them both and who listened with the focused attention of someone tracking every word rather than waiting for her turn, asked how long these provisions had been in the system unaddressed. I said the longest had been there for 2 years. She looked at the board member to her left, said something quietly, then looked back at me and said, "We are going to be having some additional conversations with the executive team about legal oversight. I want you in those conversations." I said I would make myself available. The general counsel remained. He knocked before entering my office now. He sent documents with lead time. He stopped describing contract language as gibberish, at least within my hearing. The CFO resigned 4 months later, officially described as pursuing other opportunities. His successor came up through finance at a company with a serious legal function, which meant she understood that contracts had implications and that the person who managed them was not furniture. The CEO stayed. He treated me differently after the boardroom. Not warmly, we had never been warm, but with a new kind of attention. The attention you pay to something that has demonstrated it can affect you. He had learned that I existed in a way he had not known before. That was enough. What changed most was the organizational culture around contracts. It happened slowly, the way cultures change, not through announcements, but through incidents and precedents and the accumulated knowledge of what happens when you ignore the fine print. The sales team stopped signing things without sending them to my office first. Business development began scheduling contract reviews into deal timelines. Someone created a checklist. Someone else created a training document. None of this was dramatic. None of it made the news. It was the kind of change that looks from the outside like nothing at all, and from the inside feels like the slow correction of something that had been tilted for a long time. 6 months after the settlement, HR sent me a compensation adjustment email. Performance rating, highest designation in the new rubric. The adjustment, significant. Reviewed and approved by the audit committee. Effective immediately. No pending timelines. No budget reallocation language. No reference to legal. I replied with 2 words. Thank you. I closed my laptop. I sat in my office, in the quiet that accumulates in places where careful work gets done, and I thought about a partner at a litigation firm who had slid a contract across a desk 17 years ago and pointed to a single clause and said, "Somebody signed it without reading it." The most powerful thing you will ever hold in your hands is not a weapon. It is a contract. I thought about all of it for exactly as long as it took to finish my coffee. Then I opened the next document in my queue.